Judge Vincent LeBlanc of the Superior Court, State of New Jersey, Chancery Division in Middlesex County, on the matter of the Township of Piscataway versus Andrew Paglia and others. And it's, the docket number is, go back and find that, it's L-7140-19, and we're conducting this by way of Zoom. And I'm in the courthouse, but we're dealing with counsel and elsewhere. And I have the appearance of plaintiff's counsel for the record.
Yes, thank you, Your Honor.
Actually, it's Mr. Goomer. Go ahead, Mr. Goomer.
Your Honor, Roger Moore for the Piscataway logo.
Okay, great. And Ms. Studholm, your appearance?
Yes, defendant's brother, thank you, Andrew and Cindy Paglia, and Studholm was Pollock.
Okay. And Mr. Dellapella.
Co-counsel for the defense. I realized just a few moments ago that I had not yet filed an appearance in the quasi courts, and I apologize for that oversight. But in any event, it's not my argument to make today, Mr. Holmes, so I'll just turn on my mute and listen to you.
Okay. And that's fine. I don't know that, yeah, that's probably the best, unless you want to just put a call into from Chambers to see if we can get speakers for the courtroom. But if I can hook into the, something that can hook into the laptop, right? Okay. Apologize for the technical difficulties. So we did receive your papers, and Ms. Studholm, this is your application. I'll hear from you.
Yes, thank you very much, Your Honor. First thing that struck me is that, ever since we've been talking about this, which is that, before it was conceived, we've had certainly the March 23rd, 2018 letter from Eminent, which is to date the sole actual basis that they would be framing us. The fact that this parcel was going to be part of the park, for this year's letter, they've been back off that in the past couple of days. And I don't know if some county said, hey, Eminent's told us it's going to be part of the park.
But I saw that in your papers that you said that they abandoned that claim of wanting to do something with the park, but I don't think that they've actually said that, right? You're just saying that they haven't argued it.
Well, up to now, I did report their engineer's letter. Their engineer said it's going to be part of the park. Now they're saying, well, it'll be open space, but that's the park. So that's the difference. I think the salient of their claims was for this sewer line. And yet, we see nothing that says they have to tear the house down now. At some point, they were going to build the sewer line, and they really had to go through the house, and they might need to tear the house down. And they might do the house down.
I'm sorry to interrupt. The court clerk is on the, we're having trouble hearing the litigants on the court record.
So I think you need to be closer to your microphone, because I am having difficulty hearing you as well.
Okay, great. Thanks for joining me. So I'm actually lifting up my hand now. Can you hear me now?
That's a little better, but not terrifically better.
All right. And there was no problem with this on Monday, right?
No. Sam, can you hear better?
The court clerk says it's better now. I can hear it.
Okay. Can you hear me, Ryan?
Yeah, but I'm going to just move elsewhere as well.
I called B as well. He said he's gonna let someone know to bring a speaker.
Okay, so I apologize, Your Honor. I'm actually now holding my device up, which I can do, but if I have to put it back into a document, it's going to just take me a second.
Okay.
Oh, and my links, my first website just dropped. Just once in a while, always at the worst possible time, so I apologize if we try getting that back up in the background. I don't know that we're necessarily going to need it unless we get to arguing over something specific in the papers. Anyway, the
this court is twofold. Whether the commissioner's hearing will essentially continue on hold, the status quo is nothing's happened with that. Whether that will continue to stay on hold, pending the disposition of the appeal, which could be soon. Appellate division tells me, I'm out of luck with reinstating. I guess I could do that. But I think it'll be soon, and I think we're reinstated, and hopefully they'll hear us soon, because it's an old law. So whether the court will say, yes, the status quo is, commissioners dormant at the moment, and don't revive it. Let's see what the appellate division has to say, because this is going to be an expensive, contentious hearing. The parties have just never been able to get any close on price. I would submit it's because the plaintiffs have never agreed with the black letter law and all the proofs over all the years that the use was perfectly legal. If they would have said at any point, rather than, oh, please rebrief it, which I did at my client's expense, it's not questionable the use was legal. If their appraiser were to say, yeah, use is legal, the house is still with lot, well, then we can fight over that. But with them continuing to refuse to admit what
You're breaking up.
But they lost the litigation. I think I'm sorry. They didn't appeal that in 2011. It's clearly illegal use. But as long as they're contesting that, this is going to be a difficult and expensive commissioner's hearing. I don't see any need to revive it, and given plenty of opportunity, plaintiff has to present it. So that's one thing, commissioner's hearing. The next thing, I guess, the personality, it has been moved. This court has expressed hope that Mr. Brewer and I can work out the issues as to that. I still think we'll be able to. I don't necessarily see any fight over that, although the court could give us some direction, as I suggested in my papers, that could be helpful, would be appropriate. Then we have the demolition of the house. Again, to date, there is nothing that suggests any sort of imminent need to demolish that house. The only piece of engineering gig, if you can call it that we have, is that Google screen grab from Exhibit D, which shows what they claim someone drew on there, an anticipated alignment. It shows a curving pipe coming down Sutphen, curving along through the front yards of the houses along there, presumably so as to avoid digging up the street. That makes sense. I'm sure they'll have to get easements from those people. Then it does an interesting thing. Instead of continuing a very, very slight angular shift, which would draw it along a road-type path that is already within the park, and then it's alongside the house, instead, it makes a change and comes in at a right angle. It's not at a right angle to River Road, this land. It comes in at a right angle in Johnson Park. The court can see that. It's the last of, I think, 4 pages of Exhibit D. And I always make sure it is Exhibit D to everything. Everything I file, that thing is Exhibit D. So if the court wants to take a look at it, I can pause for a minute.
Sorry about that. I just need my battery's saying it's dying, so.
Yeah, I don't know if the court maybe wants to look at like Exhibit D while I'm talking about it.
No, but Mrs. Studholm, I've read your papers. Some of the things that you're arguing are the issues that were taken up before Judge Rivas when he heard your case back in 2019. I went back and I was able to hear the recording of that hearing, and the things that you're arguing were matters that were taken up before him, and that obviously then become the subject of the appeal that you're trying to reinstate before the appellate division. So at this point, I'm not sure that I can even address those, because that's really things that should be taken up before the appellate division now.
Well, Your Honor, they're two different things. Before Judge Rivas, and hopefully soon before the appellate division, the question will be, for the condemnor, with all the resources of the state, small enough state, this is a town, government, to forward on such a, I don't even want to call it thin right, on essentially nothing. Who has the burden? Judge Rivas kept asking me, well, what does your engineer say? Well, my guys didn't have to hire an engineer, and my engineer wouldn't have anything to go on. They haven't given any grist for the mill. But that question was as to the taking. This question is as to a stay of demolition of the house, pending they are showing you why it needs to come down. So it's the same question of the town, for whatever reason, choosing not to come forward with, it would be relatively minimal, to prove their need. But before Judge Rivas, can they even take? Before your honor is, have they shown enough to justify disturbing the status quo and demolishing this house? So there are very good questions for that.
Give me 1 second. And that's not the same charger though.
Oh, it's not the same charger?
Yeah.
You don't have yours?
Hmm?
You don't have yours?
No. Okay.
Do you want me to go get my laptop?
What's that?
Should I go? Oh, my laptop won't connect without the Ethernet. Hold on.
You know what, we may just have to take a brief intermission and let me hook up to a, because I'm on now on battery saver and go onto the, I'll try and hook up my camera onto
Do you want me
there.
to get your camera from the?
Yeah, please. So, Sam, are you still with us?
I am, Judge.
Let us, can you take us off the record and take us off of Zoom and that everybody can reconnect then?
Yes, Judge.
Will that work?
Well,
Okay.
Yes.
we'll have
No, I can place all the participants except for Your Honor in the waiting room, and then we'll resume when everyone's ready.
Okay, super. Thank you, I apologize.
thanks.
Apologies, everybody be able to hear us now? Okay, Ms. Studholm, you want to continue?
Yes, I'm sorry, Your Honor, and I was just answering the court's question as to hasn't Judge Rivas already, decided on this issue, for better or for worse, that's before the appellate division. And my point was, the question of the adequacy of their engineering proofs, the utter lack of their engineering proofs, was before them as to the taking. And it's before this court now as the question of whether the status quo needs to be disturbed and the house demolished, which can never be the uniqueness of any property, put the pagans back where they were once it happened. We don't have any evidence, and we still don't have any evidence, that the town has any need to demolish this house at all soon, let alone, the next few days. And that's my point in raising the exhibit. Did it have plenty of chances by now to say, no, our information is all by now, we've got engineering reports if we want to. Haven't seen them, certainly haven't filed this court, Mr. Gruber is playing with them now by saying, let's, time out and reconvene and extend the CROs until then. But I just don't see them. And there's no reason that no one's going to get hurt if this court extends the TROs, which already in its order arguably would be through at least the appellate division's decision. Extend them, and if Mr. Gruber's client wants to come back and say, no, we're very sorry, we really should have showed you why we have to do it now, this court can always revisit that. But there's nothing now to address why the house can't just stay up. The other thing is, I understand from my client, the house is wide open, once again, not being cared for.
Well, me, I've been informed the court smart is no longer recorded. We will address this now.
Okay.
Which means we probably need to go back to where you started up again, Ms. Studholm. I
I'm so
apologize.
sorry. Okay, let me know when I can start.
Okay.
I think it would be best if everyone went back to the waiting room for now while we sort this out.
Okay.
So, court apologies for any
Thank you. Okay, we're back on the record, and the court clerk advises that there have been some technical difficulties. So, with all my apologies, with his apologies, Ms. Stodholm, you want to start over?
And I apologize for what, do you mean start over from the beginning?
That's what he start over from the beginning.
Okay, I will, and I'm sorry, because I'm just gonna have to look through this again. So we're here pursuant to the court's order of Monday, July 26th, which order itself did stay the demolition, but of course can be revisited at any time. And at the moment, the issues as to the personal team, they were already mostly moved on Monday. I'm not quite sure why the plaintiffs replied. At the moment, stressed communications as to those, maybe because they were really mostly in communication over the past couple of years. But the property's been moved. The court asked me and Mr. Boomer to, collaborate to help the Paglias have appropriate access to their property. I see no reason why we wouldn't be able to do that. I suggested that the court might possibly give them the spur by setting a deadline. What I proposed with my neighbors, I think would be appropriate if the court wanted to order. But I think the personal is relatively mild issue. What we have before us is the question as to whether the status quo will be maintained in two ways. First, to have the commissioners hearing, which essentially has been functionally in abeyance since the end of December 2019, when Ryan Jones, Mr. Boomer's predecessor, had long ago advised the court that he reached out to the three appointed commissioners at that time, when only reached one of them, and then COVID hit and nothing has happened. So there seems again to be no reason, certainly we can't think of any, plaintiff hasn't put forward any, to hold the commissioner's hearing, which is going to be contentious and expensive. I took some time describing that before. I don't think I really have to go into that again. For the record, it's somewhat irrelevant. It's going to be contentious and expensive. So there seems to be no reason not to stay the commissioner's hearing until the appellate division has acted, which should be reasonably soon. Then we get to the house.
Let me just say for the record, we did receive a copy of your filing with the appellate division. You're seeking to revive the appeal before the appellate division, and Mr. Calvin, who is Judge Toto's law clerk, contacted the clerk at the appellate division. They have received that. They're in the process of acting on it. Mr. Goomer, you'll have an opportunity to respond to that motion. I don't know if you've done that already, but I guess once they get your response, then the clerk there indicated that it would be within 10 days that they would act on that. So, Mr. Goomer, you haven't replied yet, have you?
No, we've been working on it.
Okay.
We'll help it. We have.
I guess the sooner it's received, the sooner they'll act. So, just to give you both some guidance, my intention is to provide you with a written decision on this matter, and that probably fits into the appellate division's scheduling. That because I think I have to wait and give them an opportunity to act on that motion, and so I would plan to give them that opportunity if we don't hear from them, and that's why I checked. I just wanted to see what their scheduling was like, but that's a relatively short period of time, and I think that we would probably wait for that and see what happens. If the appellate division reinstates the appeal, then the jurisdiction is out of my hands and I can't take any action. If they decline to revive the appeal, then it's up to me to make a decision, I think, on the application. So, but go ahead, Ms. Stodholm, you want to continue?
Thank you, Your Honor. Yes, so as the House, the question is, again, if there's any means to serve the status quo, I think certainly not in that short time frame that Your Honor just mentioned. Again, I should mention, I think Mr. Boomer knows this, he's seen the docket too. The appellate division has, of course, accepted the filing, but they asked me to reformat my exhibit. My colleague has done that, we'll get those shortly, but because there's so few exhibits, I don't think there's any question for Mr. Boomer. I don't think it's hurting him or delaying him, but he should definitely call me if he has any question about that. We're just going to be uploading them with exhibit A, exhibit B, exhibit C, D, everything like that. So that, I don't think that will delay that. I also anticipate this will be relatively quick, depending on how much time Mr. Boomer needs to respond, whether they let me reply. We'll know pretty soon whether they're going to take this up. So in terms of the house, maybe at this point, I don't need to belabor that. The question would be, we certainly would renew, or as far as the appellate division is concerned, file a new motion, offer the exact same way to stay, and then they can decide that. So I don't know if Your Honor would like me to talk about, in the event that the appeal is not reinstated, what the proof submitted to date would indicate would be the correct result as to the house going forward, or if that's a little premature.
Yeah, no, why don't you go ahead, because, I'd be working on that premise as well, depending on what the appellate division does, so.
Yeah, okay, thanks. So, again, we haven't seen any reason to tear the house down. But the thing has a reason that I have a need to demolish the house so that digging can start, physical engineering can start, to measure something, I don't know what they would need. They certainly will come in and tell the court why. Say, we need to demolish it because. But because we have one piece of paper, unsworn, that purports to be a screen grab from 3 years ago, that someone was told, put the line through the house. I think that's what we're going to find here. That's why there's so little information. Based on that, to disturb the status quo, we've come forward, we're going to move it.
See, when I listened to the hearing before Judge Rivas, you made that argument to him, and I think he just found, and it was his belief that it was a valid taking of the property, and that there was no need for an inquiry into that. And that it was a valid governmental purpose, essentially. So isn't that, so I don't know that if the appellate division doesn't take the appeal, I think I'm bound by Judge Rivas's decision, aren't I?
Well, I think there's going to be two things on that. Again, we've been back in the record a couple of times, and I apologize for repeating myself, and of course repeating this question, which is the question before Judge Rivas was whether the taking has a public purpose, has a demonstrated public purpose. The question before this court now is whether there's a need to disturb the status quo to demolish the house. Pending, for example, the commissioner's hearing. If the appellate division will reinstate, appeal that, they're telling no, and if we saw it served, that would be granted some of this. Then the question is, well, maybe the commissioner's hearing springs into action, and we'll have a similar issue. Is there reason to disturb the status quo, demolish the house? It's unique. It can't be put back in that position. With the town having, and it really disturbs intelligence. Why, over these many years, they have shown nothing other than that Exhibit D. That Exhibit D certainly doesn't support any sort of imminent need for tearing the house down. I don't think it supports a take. I think that's what the appellate division can find. And we now have this other issue, which Judge Rivas had two asserted bases for taking in front of him. I think they've abandoned one base. This court may have captured it, expressed that no, the court disagreed with you, they don't necessarily abandon that base, but it's at least an issue that unfortunately the appellate division have to grab based on Piscataway's own public statements. So we've come forward with an enormous amount here to say, here's the status quo, here's what we're doing to vindicate our rights. We think we've shown we have a good chance of prevailing on appeal. The appellate division should act on that pursuing anyway, purely as a statement. And they'll be injured if there's a demolition. That's always true in real estate. Plus, more so in this case where the town has been so intransigent on the question of the legality of the use they were making of the property. In the face of just black or white, there's no legitimate question. Their own zoning officer has confirmed that as the legality of the use. And this entire matter would be proceeding on very, very different tone if they would just acknowledge that the use was legitimate. And so the income-based approach would be a legitimate valuation. To happen, your commission needs to demolish the house. So, Your Honor, I think, we have to come back, or we'll see what happens, or if Your Honor says, if the appellate division reinstates the appeal, then this court doesn't have any jurisdiction, and you have to ask the state appellate division. If they don't reinstate the appeal, then the question would be what to do about the commissioner's hearing. That could then happen. And then the question is what to do about the house during the commissioner's hearing. Plaintiffs show no need to take the house down and permanently impinge on the status quo pursuant to the commissioner's hearing. But they can always come back and show that if they were to have it. So that's I think where we stand as to those things. And I apologize for some fits and starts of the argument with the reporting problems. If the court has any questions for me, obviously I'll happily do what I can to.
I appreciate that. Isn't really the status quo, though, that this matter has kind of been on hold, but there's been no appeal or perfected appeal of the decision of Judge Rivas. So essentially, the Township of Piscataway owns the property as of 2019, and there's been no tenants living in the property since 2019, 2020. Am I correct?
My understanding, Your Honor, is there hasn't been a tenant since August of 2020.
Okay.
And again, for some reason, the town took no action towards possession in all that time. They permitted the Packaways to keep paying their taxes. They permitted the Packaways to keep registering their debts. They permitted the Packaways to keep collecting rent. They permitted the Packaways to keep maintaining the house. They did nothing. I don't know what woke them up in August of 2020. And then there was the question of the lockout of the property was cared for, and that went on and on. The mere fact that they own the house, in the face of our motion saying it will irreparably harm the status quo if they take it down, and they don't show any reason to take it down, then I can be defeated, I think, if they show a reason they need to take it down. We haven't. I think if I understand the court said, well, they own the house now, so they don't need to make that showing, they can just take it down. I don't think that's correct. I think in the face of a motion per se, they have to show why they need to take the house down, why they need to disturb the status quo, why would they be harmed if this court grants a continuation of the TRO. They haven't shown it.
Okay. Thank you very much. Mr. Goomer?
Thank you, as you indicated, the appeal was stated, the applicant has to get a stay from the college. If the appeal isn't reinstated, in regard to that, we presented arguments in our brief as to the fact that, for 15 months after the dismissal, there was no action taken by the respondent in regard to reinstating that appeal. And that's been before the appellate division to make a determination of what was reinstated. As we presented in our brief, the township has tried to bend over backwards toward the Packaways in order to make sure that they commit the work of property. I think back in September of 2020, when the township was finally aware that the property was vacated to tenants, during COVID, the township didn't want to, it's kind of in a limbo with all the COVID issues that were going on. We went ahead and took possession. And at that point, we provided notice to the Packaways that, they have 30 days to remove the property, but of course, we have an obligation to reimburse the relocation costs. We tried to work with them since that point, to the point where the Packaways actually had agreed to have the township move the property, and we were going through that article on requesting them to provide us with station, the whole property goes where, and et cetera. So the concept center around this last state that we have to move the property, and because the time is that we're not comfortable with the situation, and, you know, the property now is in a situation where it's moving to being content, and that property wouldn't be secure in a good location. So it's been moved to a secure location with utilities and climate control, and that property is being accepted for them, and we provided them the additional 30 days to maintain the property as any. Not once has the highway ever asked the property that we have, I think it's twice that they had, and we provided them access. You know, there's never been a time where the contract has refused access to the property. So that's the property part of it, is how we really depend on that. We'll be trying to work with that, and we understand, you know, this type of proceeding can be, you know, in regards to the demolition, you know, the Township and I have provided the highway council multiple notices, we provided our brief, were provided there over a month as to the Township intention to demolition of the property. Not even yet received until this application, any objection or any response as to issues in regard to demolition of the property. The highway has had many communications with us in regard to the personal property, but not in regard to demolition. And this is a single waiver of project. In regard to that, the fact that they stated their own emergency by never actually responding to us. And because if you look at those emails, it simply says, if you have any issues or objections, please, you know, please connect and reach out to us. Not one did we receive it. So the Township, you know, needs to move forward with this solution. They've retained experts, the engineering to do the engineering design of the solution. You know, the delaying is going to cost them Township, and it's also going to affect Rutgers University, because their quarry is very serious fuel issue at Rutgers University. And this will remedy that issue. You know, in regard to whether we had a taking, we had a college purpose in a taking, you know, Your Honor, that's a practice that's all approved, that we're going to get relapse, and we're bound, unfortunately, you know, by that decision. I don't think that's an issue that we need to reapproach. So I think the real issue for the court is whether we can stay the demolition for, you know, until the subdivision makes a determination on whether we can take the issue. But if the subdivision doesn't mean anything, then we have a, you know, we've taken the property. The court made a decision. We've completed our process. We've submitted the funds to the court. We have the only item left is valuation. And at that point, there's no irreparable harm. Because then they only next proceeding for monetary damage. Irreparable harm means that we can't provide damages that are non-monetary. You know, we can't cure without monetary damage. In this case, we can cure with monetary damage. Provide them adequate valuation based on either professional hearing or any typical hearing. So, you know, I think at this point, Your Honor, you know, we'd like to proceed as fast as possible in the demolition. And I think I agree with Your Honor, if we make that decision, just to delay, you know, just to put an injunction, this is time that we would ultimately pursue our reinstate and move out of opposition pretty expeditiously.
Do you want to address the argument raised by Ms. Studholm that the Township only provides a map showing the route of this sewer going directly into the house, going down the hill from Rutgers Stadium, across River Road, and then through the house and into the park? And I see it's kind of a direct line connection, but I think Ms. Studholm's argument is that very easily it could go to the right or the left of the home and not necessitate a taking of the house and demolition of the house. And so why is it there's no, her argument is that there's no engineering to show that need to go in a straight line as opposed to the right or to the left. What about that? And is that something that comes back before the court at that point?
No, I don't think so, Your Honor. Judge Rivas actually had that conversation with West Bank earlier. Judge Rivas determined that we don't have to, do engineering plans or any other scope to show that that's what we need the property for. To give a small explanation to the court as to why that line goes through the property. Stuffman Road, if you're aware of it, is a steep line. It's going to be a gravity main, and anything that turns in the line will actually fall into a substantial effect on the flow. The engineering department of the township made that determination that the best method is through the property. That being said, if you're on we also, I think the township, to get the final engineering plan for the build out of the sewer main was just, I think, a couple months ago, had authorized engineering to figure that all part to do the final step. But it's been clear that the best way for that gravity main to make it to the river where the Piscataway sewer line is, where we have to connect, is a straight line down Township Road. Unfortunately, the property is right across. Your Honor, also in regard to this, and these issues would have been for Judge Rivas, and if he felt saying it was pertinent to our public purpose, would have made that determination that he based on the law, the black letter law, what it says, is that the township does not have to, have to provide detailed reasoning as to what their public purpose is for, and we can make the determination where the sewer line goes. Fortunately, the sewer line, straight line, as has indicated, is that's the sewer house. That's the best way to do it. In regard to public purpose in regard to the park, I just want to correct the record, Your Honor. We never said that it still wouldn't be, we indicated it's going to be open space. Whether we're actually going to deed the property over to the county, and that hasn't been, of course, that hasn't been organized to the county. We don't have a property demolition laws yet, but we may have to be able to retain it as open space, part of the park, but we may have to retain ownership in that portion, partially because I think the design is indicating that we'll have to have our metering pit in order to measure the flow coming out of the property so they can build that, and also we can submit that to the county, but it needs to be on standard property, and therefore, that would also be so, I mean, we haven't changed any of our, reasons for meeting the property. We haven't modified anything. We've been straightforward the whole time, and unfortunately, it's a gravity main, and it's going to need to go straight across the property.
Mrs. Stockholm, you wanted to jump in?
Yes, thank you. It seemed my jaw dropped, Your Honor. Obviously, this is all new to us, as the court knows, because it's new to court. We're hearing unsworn lawyer, I don't want to call it testimony, an unsworn lawyer argument. Something we've never heard before. As another unsworn lawyer, I can say that, as I pointed out to the court, and possibly off the record, and I apologize for that, because I know we have to repeat some of this. But the line on Exhibit D coming down Sutton Road absolutely already has turns in it. It has turns in it so that they'll be relayed in the front yards of the houses along Sutton Road that has curves. And that's fine. I understand. We don't want to take up the road. It absolutely has curves in it. It will be gravity feeding. The question is, once it hits the River Road line, I'm not sure you can't tell from this one map, I guess, the big wide ass. Then the interesting thing about the straight cross is that it's drawn right at the moment. They chose to put their proposed manhole at a place where there will be a right angle from a certain point in River Road. And I don't know if that certain point in River Road is something that's already engineered in place. I don't know. I would love to know, but they've never said. They have a line going from the house, and as Ron pointed out, if it went at a slight angle so that it could bend, just like it bends in River Road. If it needs to intersect the right angle, which I don't believe is the case. Often sewer lines do things, they're laid in roads, and roads intersect at right angles, but I don't think it would have to be. It depends on the direction of the flow. If you come in at a slight angle, as long as the flow is going to the angle, you don't want the flow to sort of have to do a hairpin turn I think someone, town hall was leaned on. You go around the map and the sheriff goes to the house. And I've seen, no, well, Mr. Gill was shaking his head, but he's had years and years and years to provide me to the contrary. And as a week to provide this court to the contrary, I don't think there's anything to the contrary of what I just said.
But I have a question for you then, Mr. Holm. The argument that you're making, though, which may be interesting and is a good argument on behalf of your clients, but isn't it in the wrong venue? Isn't this the argument that shouldn't it have been made back before the township of Piscataway when they entertained the taking?
Oh, you're right. But as I said, we were on a quick order show caused by Jeff Rivas. You get this calculated. I thought for sure Joe Ruth would say, there's no record here, there's no record that he's taking this. So I'll give you 1 month. I'm sorry, this is stagnant. You're going to have to pay engineers. You're going to have to pay engineers. You're going to have to come in. As he said, he's hinting me that I have a burden to prove and that I could do it, quote, at another stage of litigation. I looked at that court and said, what just happened here? The town gave nothing I have never seen in my entire career as tissue thin basis. They had been forcing us to brief something we'd already beaten on in court as the legality of use, and they still kept saying it's illegal. And we're cooked up nonsense I have never seen. And as Mr. Boomer himself said, unfortunately, this court is bound by what Judge Rivas did. I think the appellate division is going to quickly say, oh, come on. And they may prove us and say, you know what? We've seen the town's proofs. They are what they are. We'll give you one. But that could be a huge budget, but we'll have to have some. But I don't know what I would say with this helping engineer. Because he'd say, well, yeah, we're good plans. I'd say, well, unfortunately, this seems to be it. This seems to be it. Plans. That's all we have. Everything that Mr. Gilman's talked about, other than the fact that, yes, something's steep. That's a lawyer. His guess is as good as mine. But what I'm not guessing about is that if they have anything in addition to Zip did, they've never showed it, and they've had multiple requests for it, including our moving papers now. I don't know what they have. I actually thought that it might be the case of Roman Plants, and Mr. Gilman might come in here armed by his client. A ton of preliminary studies. They had 3 years to do them, but no, the client chose not to give Mr. Grimmett out, to send him in here just to sort of make his lawyer argument out of engineering issues. Again, they're not showing why they need to take that house down. If they have a need to take the house down, there's nothing to stop them from showing it to this court, but they've chosen not to. They've weakened their case substantially, choosing not to show their hand. They told Mr. Gilbert, oh, you go in there and you tell the judge you just go on what's in our hand. And they let him file it. I don't know why. And as I said, I just went back to beating this horse. They haven't shown reason to demolish the house. For whatever reason, they have had, and they have had ample opportunity to show the courts why they need to demolish the house now.
Thank you. Mr. Goomer, last word.
So you and I just wanted to clarify something. You state that Judge Rivas indicated that we didn't do that later litigation. I might have missed this, but I don't know the transcript, and I don't see that anywhere. It's just before Judge Rivas. He made that determination. Because even in the transcript, it's discussing whether there needs to be a hearing on that issue, and then we might decide it based on the briefing and the oral argument that we have met the burden of proof in regard to whether we are taking a matter on the court. And it's it. So, Your Honor, that issue is not for you. So, and unfortunately, Your Honor would say, not that we left actions were wrong. We felt they were perfectly correct. I think the law indicates they're perfectly correct. I did because, the township has, I think, over 5 years trying to negotiate for the purpose of purchasing the properties. But we didn't want to have to do on this domain. The township would love to have, work with that we have to do that process, and that's why I say it's worth it, because the township does not do eminent domain lightly, and, you know, and I would not want to take that action unless that, fortunately, I did that. In regard to, Ms. Dunholm attacking, you know, my description of the line, I'm not an engineering writer, and so, and I think Ms. Dunholm actually gave quite a bit of engineering, design in regard to her turns and left and right.
I was waiting for you to tell me you were an engineer, though.
I did have a bachelor's science in biology, unfortunately not it.
Pretty close.
For one semester. Your Honor, like, anyway, stuff in order to keep these lines at the point where it's the road and it's the park, there's significant decrease in grading, right? And so any turn in that, and the pipe would have much more significant, effect on the flow than on such a deep kind of something. But that being said, I have no idea where the home family is the right turn. The only right turn connection I think would be at the way sewer main.
No, I think she was indicating coming down the hill. It's not a straight line down the hill, it's kind of going.
I was talking about the right angle intersection where I guess it's the main garage just mentioned in John's Park. It has a right angle intersection. I don't know that that's needed. He doesn't know that it's needed. I don't think it's actually relevant. All that's relevant is they show no need to demolish the house. They're welcome to show it, but they haven't. They've chosen, by this point they've chosen not to.
Mr. Goomer, you said that was briefed. Is that in the record that I can go back to? Hold on, Mr. Dunholm. Go ahead, Mr. Goomer.
Whether we met our burden for public purpose, yeah, I think that went brief before the oral argument with them to be that. I think this is just an oral argument. I could be wrong, but I think Mr. Jones was leading to the business. But I did have a little bit of an edit, and I think there was some prior to the oral argument. And that's what we discussed about the
Ms. Dunholm, was that briefed before Judge Rivas?
We certainly, your argument was about our main point. And of course, we had a couple of other reasons. Bad faith negotiation was loomed very large at that point for the reason I'm talking about. Poor Raj has always said, we would love to do this. Brian Jones was driving the bus at that point, but Raj has seen this all by credit. I would love to do it too. My clients here watching. All I have to do is say her use was legal, we'll use an income-based valuation. And they would get close to that, they'd tell me brief it, they'd say maybe, and then boom, they would refuse. And all of their filings in the courts call it an illegal use. That, from our point of view, is the problem with the negotiation. She has an income-based use for this property, it's fully legal, they've never acknowledged it, and maybe that was a mistake. So that, the briefs took up a lot of time on that. As I recall, in their briefs, they said, well, we're claiming it's sewer in part, and that's as public purposes you can get, Your Honor, and that was good enough for Judge Rivas. And my saying, there's nothing to show that they're going to actually build this line, and there's nothing to show that they have to do it this way, were not persuasive to Judge Rivas. And that's part of, to the extent the appeal focuses on the sewer issue, they're going to be taking it out and saying, well, really was it? Is it enough for the party to just say, we're going to do something? I think it's like putting the oral argument, and part of our appearance that day wasn't on the record. It was contentious and unpleasant, and part of it wasn't on the record. But I think one thing that didn't make it direct, I said, if the town said, you know what, we're going to harness a seven blink in the middle of the air, and we're going to have this line that comes down, and it's got to come down to your property, that would be laughed at court. This isn't far off that. For whatever reason they have chosen never to file in court any background information whatsoever. And they've gotten away with it up to now. I don't think that this court necessarily needs to push them to do. They just haven't shown why they didn't take the house down. The appellate divisions we were looking at haven't shown why they even take it. Those are two different questions, although they circle back to Mr. Goomer's client's choice to send Mr. Goomer forth to argue with no risk in his will.
No, I just want to correct something. Ms. Home again, the word that you got out. have the transcript, I don't remember. It was a while ago, but I don't think that Judge Rivas ever made any determination as to whether the township from purpose use is not persuasive. It clearly was that the judge, determined that we were met the burden for taking and filed it forward. So, and any of these arguments are also before other venues. In regard to the appellate division, if they reinstate the appeal, these arguments be before them. In regard to the valuation, whether what type of valuation that they can achieve, that would be before the commission and then before court. At this point, Your Honor, I don't think any of these arguments, and that's why I don't want to, harp on it, but Your Honor, I don't think any of these arguments are before you. And regarding the specific thing before you is whether we should demo the property or not, and whether you should place a pay. And Your Honor, I mean, there's a waiver argument, as I specified before, 16 months, I did not get one, or we did not get one correspondence saying, we disagree, don't demo the property. It was silent, we had plenty of communication. It wasn't much communication. Even in the past few months, there was plenty of communication. And we asked about more time, and not one. And the fact they didn't want the property demoed, I would think we could work with us to move forward. But, it's a self-created emergency. They waited until 2 days before the demolition, or at least not proceed to work with the demo on that day. But the notice to proceed in order to provide an emergency.
I understand your arguments, and I think Mr. Goomer is correct on the issue of compensation with Studholme, is that that issue is really before the compensation commissioners, if and when it gets there, and then if any court review of any decision that they make. So I don't know that that's really before me today, but I appreciate both of your arguments, and again, we'll endeavor to see what the appellate division does, and then I will be issuing a written decision, and we'll get that to you as quickly as possible after we hear from the appellate division. Okay? If we don't hear from the appellate division within a reasonable period of time, then I'll be back to you. Okay? But thank you very much. And that order will, I think, just remains in effect, right? There was no deadline on it, as I recall. So my restraint just says until further order of the court, so that that restraint will remain in effect. And I think I also provided until further order of the court, pending the disposition of the appeal in this matter. So I think that covers both contingencies, right?
I can see on paragraph 1, it certainly seems so to me.
Yep.
But again, like I said, they can always come back if they want to, and Your Honor is looking the door open for that. If I may be very, very briefly heard as to, are we off the record?
No, we're still on the record. Go ahead.
Okay, thanks. Just as to Mr. Cooper's arguments about the notice, again, that's all really is to the property. But I think something the court might want to keep in mind, and I think a word has been used at one point in the correspondence, hostage. The town had my clients and extensive family members' personal property hostage. And one of the things that was constantly being expressed to me and Mr. Delappel, the court might want to ask him because he was really more involved in that, was, oh my God, we fight too hard, if we do this, if we do that, what are they going to do with that property? And we always said, well, they could just demolish. I mean, there were huge risks in addition to the emotional risk, which I think Mr. Cooper was appropriately alluding to. And I just wanted to say that was part of the background of this as well, was the citizens' fear as to what now is going to happen to their areas. Thank you.
Thank you very much, and we'll be back in touch with you. Everybody stay well.